How to value and divide a business in an Illinois divorce. There is probably no more Byzantine and complex process in an Illinois divorce than valuing and dividing a business. The business operating spouse will always want to keep the business while claiming the business is worthless. The spouse who doesn't operate the business will want a grandiose share of the business's value without really knowing what that value is. A business's value will surely go to trial or be negotiated fiercely. The business owner and his or her spouse must know how an Illinois court determines the value and division of a business. More importantly, the litigants' divorce lawyers must understand completely how a business is valued by experts who disagree and how to apply those valuations to the body of Illinois that governs the valuation and division of businesses in an Illinois divorce. Is a business marital or non-marital in an Illinois divorce? Every asset in an Illinois divorce must first be determined to be marital or non-marital. For business interests, non-marital property is, typically, property acquired before the marriage or via an inheritance, gift. The non-marital property must stay with the party in whose name that non-marital property remains. Businesses that have portions thereof that were acquired before the marriage, such as a building that was bought after the marriage, will have those portions deemed to be non-marital. The increase in value of those pre-marital properties will also be deemed non-marital. Business interests acquired after the marriage but were purchased by assets which were acquired before the marriage may retain their non-marital character. The counter-argument is that any contribution from non-marital business into what could be a marital business property is transmutation. Transmutation is based on the presumption that the owner of the non-marital property intended to make a gift of it to the marital estate. In Re Marriage of Vondra, 2016, Ill App, 1st, 150,793. Furthermore, any personal effort from a spouse post-marriage towards a non-marital business can be considered by an Illinois court. However, no reimbursement to a spouse who worked on a non-marital business shall be made. If the marital estate reasonably has been compensated for his or her efforts, it shall not be deemed a contribution to the marital estate and there shall be no reimbursement to the marital estate. 750 ILCS 500 thirds, c. 2, b. The less clear it is whether a business is marital or non-marital, the more likely the business property will be deemed marital. How does a business get divided in an Illinois divorce? Parties to a divorce where one or both spouses own a business can divide the business's value and/or the business's future income however the parties agree. Agreement as to value and division of a business is often only possible when both parties have equivalent knowledge of the business's operations and future earnings. Equal knowledge of the subject business is usually only possible if both parties work in the business. Courts will rarely award portions of a business to both spouses, where the now ex-spouses must work together. If both parties do not work in the business, there is usually a massive gap in the understanding of the business's value and income between the spouse that operates the business and the spouse that does not operate the business. Therefore, division of a business and its value is not resolved until that knowledge gap is closed or a divorce court rules upon the value and division of the business. Once deemed marital in nature, the business, or portion thereof, an Illinois divorce court, shall divide the marital property without regard to marital misconduct in just proportions, 750 ILCS 500 thirds, d. In Illinois, this division of marital assets is not a pure 50-50 split of each asset. Unless the parties work together in the business and agree to continue working together, the business will not be divided between the parties. The spouse that knows how to continue to earn income from the business will inevitably be awarded the business. The business operator's spouse will be awarded the business because they are the only one who can take advantage of the reasonable opportunity of a spouse for future acquisition of capital assets and income. 750 ILCS 500 thirds, d. 11. The spouse that did not operate the business will inevitably be deemed to have contributed to the family to an extent that allowed the business to flourish and, therefore, should be awarded a portion of the value of the business. The portion of the value to be awarded is usually less of an issue than the value of the business itself. How do you value a business in an Illinois divorce? When discussing a business in an Illinois divorce, we are virtually always discussing a closely held corporations or partnerships. A closely held corporation is a corporation whose stock is not freely traded and is held by only a few shareholders. Black's Law Dictionary, 11th ed., 2019. Businesses cannot typically be divided in two. The business operator almost always keeps the business after an Illinois divorce. If the business has been deemed to be marital, a portion of the business's marital value will be awarded to the spouse that will not operate the business in the future. Furthermore, closely held businesses may have more than one shareholder. The shareholders are usually bound by an operating agreement that requires that they only sell or transfer shares to each other or third parties only if agreed. The value of the business is the fair market value. In determining the value of assets or property under this section, the court shall employ a fair market value standard. 750 ILCS 500 thirds, K. Fair market value is what the property would bring at a voluntary sale where the owner is ready, willing and able to sell but not compelled to do so, and the buyer is likewise ready, willing and able to buy, but not forced to do so. This is theoretically an objective standard of valuation. The value of particular property is set by the forces of the marketplace at a given place and time. Chrysler Corp. vs. IL. Property Tax Appeal BD. 387 Nebraska 2D 351 IL. Appellate Court, 2nd Dist. 1979. Citations omitted. There are no voluntary sales, however, in most closely held corporations. In a close corporation, the corporation's shares are not listed on a stock exchange or actively dealt in by brokers, and, therefore, there is no established market for the corporation's stock. The shareholders of a close corporation, however, like those of any corporation, do realize a value from stock ownership in that they have certain rights of control or future profits. Furthermore, courts have recognized an ascertainable value for shares of stock in closely held corporations. In re Marriage of Olsher, 397 Nebraska 2D 488 IL. Appellate Court, 1st Dist. 1979. In lieu of a voluntary sale, the courts must rely on expert testimony to present evidence as to what the fair market value of the business would be if there were voluntary sales. Placing a fair market value on the professional corporation is an art, not a science, and the court must rely on expert witnesses to assist it in this difficult task. There is no exact formula that can be applied, so the trial court must rely on experts who may differ significantly in both methodology and valuation. The trial court must consider the relevant evidence before it, determine the credibility of the experts, the reasonableness of their testimony, the weight given to each of them, and their expertise in the particular area of valuation, and then determine fair market value. In re Marriage of Gunn, 233 IL. App. 3D 165, 183, IL. App. Court 1992. Experts can opine on hundreds of factors that determine or modify the value of a closely held business. It may be tempting to forego an expert's analysis and just lean on the value of a share of stock the last time the shares of a business were bought, sold, or transferred. Transfers of stock of closely held companies, however, are not an acceptable way to determine the value of a business. Business people can and will contract for everything, but that means that the valuation process may be contracted for so long as the non-member spouse has an option to contest the valuation. Business valuations for the purpose of divorce are extremely complicated. If you would like to discuss what your business is worth, or isn't, contact the law office of Russell D. Knight to speak with an experienced Illinois divorce attorney.